All right, welcome back to the joint hearing of the House Judiciary Committee and House Human Services, looking at juvenile justice issues. And we're back to the Office of Child, Youth, and Family Advocate. Thank you for being able to be back here.
Thank you, Chair Lalonde. My name is Matthew Bernstein. I'm a child, youth, and family advocate in the state of Vermont, and with
advocate with OC Wi-Fi.
I just want to say quickly before we resume here, for those of you that don't know, I'm a lawyer, a former high school teacher and a lawyer who worked in this field, representing kids on an individual level, worked with a lot of youth who had dual involvement in the foster care and juvenile justice system, youth who were incarcerated in another state. And I've been to a bunch of facilities. And Lauren has her own perspective on this.
Yes, I think most relevant to my experience is as a former worker with the Department for Children and Families. I worked in the residential licensing and special investigations unit, which regulated, licensed, investigated residential treatment programs, adoption agencies, and youth shelters. And I wrote some of the Woodside regulatory reports and investigations.
Thanks. So where we left off was starting to talk about some of the facilities and the more restrictive placements on the continuum of placements. And I guess real quick, I just wanted to say, because there was some discussion earlier about where GCF might place youth who were raised the age youth, but not youthful offender or big 11+3. And I guess we're going to come to that, but I think I don't have full information, partly because it hasn't been provided. But my impression is there are very few youth who are placed in secure facilities such as Red Clover, who fall into that, who thread that needle of not big 11+3, not youthful offender, and charged to under raise the age as an 18-year-old or 19-year-old in the family court system. It's a long sentence, I know, but I think I would hear evidence to the contrary, or DCF could present that that's not true, but that's our understanding and our experience. Where I do think youth are often placed, and that brings us to this slide, is in the residential care system, and that's a huge topic. I think one thing to emphasize is sometimes when we talk about youth lacking accountability, who are legal adults who can sign themselves out of things or don't need to do systems and services. Sometimes that's because they're asked to. I think it's important to focus on what those services are that are being offered, right, and whether those are relevant to the youth. And our residential care system for youth who are younger than 18. Is really, it's very expensive, and there's some good programs in Vermont, but largely it is to fill a gap because there are not, more community-based supportive services available. And so this slide, and nationally, there's a bigger conversation happening now. There's federal legislation passed. If any of you are Paris Hilton fans, you may have been following this, but Paris Hilton was placed in a residential facility and is championing this issue at the federal level. And President Biden just signed new legislation to study the residential system nationwide. And that's because there have been, not just at Woodside, but at a lot of places nationally, systemic abuses of youth that are really horrific and that were ongoing and that use public dollars, right, whether federal or state. And it's really concerning. And so it's called the Stop Institutional Child Abuse Act. That's the federal legislation. And it's really worth looking at. And we didn't link it on our sources, but it's a really good piece of legislation that's going to study this system. So in Vermont, one thing we're calling for is a study of our residential care system, because it's not clear how much we're spending on. I have some numbers on here that are estimates based on what we know from other places. But it's really expensive. And, we have contracts through our ability to gather records. We have all the contracts right now, and we're going to do some sort of analysis of them. Some of them are direct. The financing is complicated. Some of them are direct contracts. Some DCF pays for the facility, whether there's somebody there or not. There's certainly good arguments for that from a business standpoint, right? That to keep the lights on, et cetera. But it should motivate us to ask if that's the best use of our money and what we're getting for it, even when that bed is filled. So anyway, I'm being a little long-winded. I want to make sure we get through all of this. The last two bullets here are really important. So Title IV funds and Medicaid funds, as I said, are the two main sources of federal dollars in the area of child welfare. They are not available to pay for for locked settings. And, that's an intentional policy choice at the federal level for obvious reasons, right? The feds want to incentivize states to create supportive upstream services, not locked facilities. So, the more we invest in this deep end of the system, I can't say enough, the worse the outcomes for youth, but also the more expensive it gets. Here's an example of that. So this is a little bit complicated and I don't want to dwell on it too long, but this is essentially federal reimbursement to Vermont. This is DCF data. This is a chart that we made by quarter starting in 2020. And that red dotted line is when federal rules changed through the passage of the Families First, the FFPSA, the Families First Prevention and Services Act in where this dotted line is when Vermont could no longer claim federal dollars for residential care after 14 days. So basically the Fed started to incentivize here keeping youth, youth could stay in residential care up to 14 days. And after that, they either had to be placed in the community or the residential center had to achieve this higher qualification, which Vermont, no residential care facility in Vermont has done. So anyway, as you see, the average claim per child has gone from about $3,000 in 2020. It actually dipped into the negative in some case. We had to pay some money back based on some, I think some like improper, drawdowns because of administrative stuff. And this is complicated, all this stuff, but this just shows like increasingly federal dollars are not available for these settings. So it is very expensive. One big thing we want to emphasize is we have right now Red Clover, which is our 4-bed locked. Oh, sorry. Yes.
Todd Nielsen. This first time doing it, I'm a little nervous. I couldn't see the damn date on that thing.
Oh yeah, it's a little hard to see. I apologize. If you, let's see, is this on our website? You have a copy, you should have a copy. Lori has a copy of this.
Could you just please tell me the date? Right?
On the left?
Where the red line is.
Oh yeah, it's January 1st, 2022.
Oh, thank you.
Yeah, no, I'm sorry. It should be bigger. Drawback. Thanks for your question. You're doing great. So we have this locked facility that just came online in October.
Yep.
October 2024. So this is a great chance to gather data. I mean, setting aside the quality of the physical facility and even the programming by which, actually we should say there's a point on here. We've heard rave reviews from kids about, I don't say that facetiously. We've talked to some young people who have had good experiences in this locked facility. But setting that aside, this is a great opportunity to gather data to see if 4 beds might actually be enough. And again, everything that's been presented on Raise the Age, we have heard we need locked facilities. I'll speak only for myself because I haven't heard all the things, right? But I've not heard we had 5 youth on this one day that had to be locked up for very serious issues, and we couldn't accommodate that for whatever reason, right? It is quite possible that 4 beds will be enough. And I just don't understand why we're rushing based on no data to build a 12 to whatever, it keeps changing, 22 bed? 14 to 22 bed new facility that we build from the ground up at a huge cost, which by the way, I think also has not been presented to this body. There's a lease build contract. I've not seen a clear, I've heard numbers thrown around, but I've not seen a clear presentation of what it's actually going to cost. I can't for the life of me understand why we are striving so hard to build this without understanding if we need it, what we need, what the treatment needs are, et cetera, at this astronomical cost with racial justice issues that we've outlined before. And so what we think we should do is, and we're going to gather some of this data, our through our ability to get records and information, we will present to you some of this data, but, we think DCF should present it to you as well, because, it's really worth understanding, given that it just started, what the data is from there. Do you want to talk about this? Yeah.
Sure.
We have 5 more minutes.
I would say since DCF has been providing its high-end system of care reports to the legislature and or the raise the age reports, consistently phrased in those reports, as I look for similarities and differences, they note that while youth subject to delinquency, youthful offender, or criminal proceedings may be held within an architecturally secure facility like Red Clover or potentially Green Mountain Youth Campus, most justice-involved youth do not represent the level of risk to be placed within such facilities. That is from DCF. That is from the people providing juvenile justice services. So I just want to note that. And they have been saying that for years now in their reporting. And so I come to the legislature as a former Woodside regulator, and my desire to slow down and assess Red Clover at 4 beds is out of experience, but also out of fear, given the harms that occurred at. And so what I present as well is, as we are developing, changing, reforming juvenile justice, there have been minimal systemic changes to really ensure that the systemic abuses of Woodside do not reoccur, right? So that is in the licensing. The residential treatment program regulations that would govern a locked facility have not changed. They still exist. The same exemptions for locked facilities still exist. I want to make sure I don't. Yep. We talk about that in the next slide as well. So DCF maintains the licensing authority over Red Clover. Red Clover is run by a private for-profit entity. DCF is also the placement authority of the children in custody. So there are still options for administrative placement with the 8-day hearing. So our due process has not changed since Woodside. I would also say Red Clover is licensed for 13 to 18-year-olds. So given that current regulation, 13-year-olds can be strip searched in Vermont routinely, regularly. And they can be used, we can use mechanical restraints on them if the facility deems that's necessary. And again, that threshold of what deems it necessary has not changed since Woodside. So I come to the legislature out of great worry. If we say that no one person was responsible for the atrocities at Woodside, then we have significant work and reform to do in order to make sure it doesn't happen again.
Is that legislation or is that the rules and procedures?
Rules would be the RTP regulations or residential treatment program regulations through the rules process. Due process, that's statutory, so that would require some changes. And I think there's also some legislation proposed about restraint seclusion, so that could tie in as well.
Which I think has been introduced.
Yeah.
Is in human services. Yeah.
Yeah.
Okay.
Yeah.
All right. Thanks.
And I think Marshall Paul would, is, who is on your list, would be the expert on the 8-day hearing. I mean, among this process. And when we say Red Clover's received positive reviews so far, I mean, that is really true. Like, and in fact, we've heard reports that some youth have actually sabotaged their unreliable information, sabotaged their placements at a less restrictive setting that was lower quality in order to get to Red Clover because they actually felt like they were treated well there. So that is all true. I think, there's something really upside down when your most restrictive setting has your most youth oriented positive reinforcement, right, for young people. Obviously, everybody wants this to happen earlier, so youth aren't trying to get to a secure setting. And then the second point there is, Woodside, as many people have told me, existed for decades and underwent a lot of ups and downs, right? And also received positive reviews at some time, which I'm sure were true. But by the end, what was happening was systemic abuse. Sure, you could say there was a couple of bad apples who were perpetrating that, but this is me speaking only for myself. My perception from what I've read is the need to have a locked facility. The problem was not that folks in leadership positions didn't know what was going on. The problem was that the need for a locked facility was this institutional cultural thing. And the reports from young people weren't taken seriously enough.
And I would say that the reports that were received, DCF cannot track the allegations at specific facilities given the inadequacies of their database system. They cannot track regular interventions at facilities given their tracking system, and that has not changed since the closure of Woodside either.
So if you called up DCF and you said XYZ residential program, I'm just trying to get a read on what their regulatory history has been over the last 5 years, they couldn't tell you. They could look it up in files individually, right? But they couldn't pull up a screen that said, oh, there was these 6 investigations all cleared.
They would not be able to pull up the number of investigations at a facility.
Again, we'd love to come back on the data system, and I know we're running out of time. So as this slide says, this is not merely, everything we've talked about before. I think it's also important to frame this as a disability rights issue. Here's what happens if you build the deep end of the system without the supportive side. So this is Maine in 2022. Sorry, this is small. I apologize. June 2nd, 2022. This is linked in our sources page. The Federal Department of Justice sent a letter with concerns to Maine saying that they were violating the Americans with Disabilities Act by failing to provide behavioral health services to children in the most integrated setting appropriate to their needs. So that's the Olmstead Doctrine. Instead, the state unnecessarily relies on segregated settings such as psychiatric hospitals and residential treatment facilities to provide services. As a result, children are separated from their families and communities. And then, whoopsies, sorry. And then, so that was 2022. And then in Maine didn't turn it around. I didn't even know this until I looked it up last night. So then, because they didn't turn it around after that first letter, the DOJ actually sued them in September of 2024. So there is a pending lawsuit. You can read this slide in your spare time. You might say this one happened in Vermont. That was Maine.
Representative, go ahead.
I am looking.
Noise. Go ahead. Go ahead, Representative Noyce.
Sorry, I just had a quick question for you around seclusion and restraint data. As part of the legislation that creates your positions, there's a requirement that you're supposed to get that. Are you getting that information?
Thank you for the question. We have gotten more recently. Up until 2024, we got a couple of
3 batches.
3 batches. Functionally, no would be, I guess, not 0, but not any amount to be able to really provide information, stay on top of it, intervene.
Yeah, we've received multiple referrals from youth and families in regards to restraint and seclusion that have not been reported to our office by DCF. So we can see that they're not reporting everything they're required to by statute.
Thank you.
Yeah. So our statute requires DCF to send us any instance of a youth restrained or secluded, a youth who is in state custody, which is what Representative Noyce is referring to. So we are working on that. There's legislation, as we said. Love to come back about that. So I don't know if folks in the room know, I didn't know this, but in 2016, the Department of Justice sent a letter to DCF. And part of their concerns were about solitary confinement, which is what eventually came out, in the federal lawsuit against Woodside. And there was a $4.5 million settlement, I believe, for those who aren't up on the story. I recommend the 7 Days article about this. So the DOJ was concerned about use of isolation and unnecessary solitary confinement, but they were also concerned about discharge from Woodside. So what this says is, this thing keeps getting in my way. Those children who are placed at Woodside can be detained there for significant periods of time, even when DCF staff agrees that a less secure setting would be appropriate if one were made available. And the underlying part is about seeking technical assistance because that's what I think DCF still needs to do still. So basically, you know, this problem has actually gotten worse, not better, since Woodside closed. In other words, a youth might go to a locked facility if we build one, but what we also need is all the levels of step down so that when they're ready to discharge, they can discharge, right? And what this shows is that that was not happening back in 2016. And, you know, our perspective is that Vermont DCF AHS has, you know, the whole structure there have been very few changes to this. And so we're setting ourselves up to be right back here again.
I think multiple raise the age reports during the intervals that DCF has provided has showed the compromised capacity of the lower levels of care outside of secure facilities. And that really leaves the state at risk for increased violations.
Representative Arsenault.
And this is a sort of a rather specific, it's a rather specific question, but I'm seeing that it says, this quote that you've pulled says, areas for potential reform include, and one of them is the risk assessment tool that is administered. So we're
Thank you
back,
for catching it.
that's Yazzie? Or is this a different?
It is not, I don't know if Yazzie was in place at this time, not per se Yazzie, but yes, that's
According to
essentially,
testimony we
yes.
just heard it, I
Mhm.
believe it's been in place since at least 2011.
2007.
2007, and then
Yeah.
it was revisited in 2011. Thank you.
You guys are sharp. That makes sense. I don't have all the details on that, but you're barking up the right tree.
I think too, this demonstrates just the concern for the juvenile justice system, not since the Woodside closure, right? There were years prior to that closure of concerns with how our juvenile justice system was running.
And I think, you know, I really think that this is not youth voice is important here, not just as a token or because, you know, we need to hear what people have been through, but, you know, so many of the voices here, you know, I think skip over this, and there's such a rush from my perception to, we don't have a locked facility. We need a locked facility as a solving of the problems. And it just runs so much deeper than that. And that is, you know, important. So,
So I ask
yeah.
you to conclude
Yep.
in
Oh, perfect.
1 minute, but don't mention raise the age because we're gonna have you back next week on that part of the conclusion. So,
I literally can't say the word raise.
no, you said it.
50 seconds.
Go ahead.
Then for 1 minute, as we talked about youth voice, I was able to visit a youth at Red Clover. And we talked for a few minutes and I was just, you know, building rapport with him. And he said, I just talked to my lawyer. I had a hearing. I don't know what the hearing was for. I was able to talk to my lawyer. Someone talked about youthful offender, but then somebody said, no, delinquency. And then someone mentioned different charges, but I didn't know if it was a misdemeanor. Someone said felony, but then one charge was dismissed. And he's like, what is this justice system? And I was like, that's enough youth voice I needed to know, right? To really show that there are changes that we need to make.
This is just an introduction and and I know Human Services will be taking up issues and we will start with raise the age and H2, which is raising the delinquency age. I don't know if we can certainly get you to, I think.
I'm on there for Friday.
We have you on there for Friday. So we'll see you again on Friday on that one. But so we're just gonna have 15 minutes and then a hard
For your
stop
time.
after. Can we get 15 minutes worth and then we'll have you back for more? Does that work for okay?
Wow, he's mean.
We can make it work. I don't know if it's ideal.
See you in a couple of weeks.
So it's awful.
It's set up, but I mean, we can get done, if you want to.
Yeah, if I could, yeah, because we have quite a few people and we're all here and I think we may not be able to fit you in when we're both together as a committee. So, see, this is your introduction to our Judiciary Committee types. Be fast on your feet, you know, so.
Oh, that's fine. I can talk fast.
While we're transitioning, I'll just say these are all hyperlinks on here, so you can click on our sources slide if you're interested in any of the sources. Now I'm getting yanked up like the Golem Show.
All right, so
Stop sharing. Oh, you just, that's the hook.
That's the gong.
That's the gong.
That's the gong. So,
They had like a hook, didn't they? Before the gong. When Gene the
Right.
dance machine.
Oh, that's
I love
Yeah.
that.
good at all.
Yeah,
I forgot all about you.
dating myself.
So thank you for
That was a good show.
your flexibility of, well, I'm not going to thank you for your patience because I'm not sure if you've been patient or not, but,
Wild.
I seem to have to say that a lot to people. Thank you for being here. If you could, identify yourself for the record and proceed, unless you just want to take questions and then have your full presentation tomorrow, or how do you want?
That's interesting. Well, I guess, sorry, for the record, my name is Kim McManus. I am with the Department of State's Attorneys and Sheriffs. I am their legislative and policy attorney. I am by no means the department's expert on justice. I am the collector of observations and of the field. I was a domestic violence and sexual assault prosecutor, intimate partner violence prosecutor in Addison County for 3 years. And so I did a lot of juvenile justice work there because I'll just, as you will hear later in my presentation, domestic violence misdemeanors and a number of sexual assault felonies do not fall in the Big 11 plus 3, as well as a number of violent felonies that I know you all wanted to discuss today. So I would actually take the temperature of the room. If after this long day, if you wanted to do questions for the next 15 minutes, wondering what's being seen out in the courts regarding juveniles, we could do it that way. Or I can run through the start of my presentation. I'll just mention the way I approached this, being very literal, as most attorneys are. I took we don't want to hear about raise the age. We only want to hear about overview of juvenile justice very seriously. And I went through just the list of questions or areas that your committee assistant put out. So I focused on 17 and under charged with a misdemeanor, 18 charged with a misdemeanor, and then the violent felonies, 17 and under, 18-year-old violent felonies that are not part of that Big 11 plus 3, and sort of rolled through in those 4 different scenarios and issues that we see, particularly around that difference of being 17 years old and supervised by DCF and being 18 or 19 and sometimes 20 years old being supervised by DCF. So that's my presentation, or I can take questions. Really, it's up to you all. You've been here.
I want to break up your presentation since you'll have only 15 minutes. Why don't we see if we have a few questions, and then I think tomorrow morning at 10:30, this also depends on how long Marshall takes, but I think he says he's going to take an hour, budget an extra 15 minutes. I don't think the 2 witnesses we have for 10:30 to noon are going to take that hour and a half. So I think we have like a half hour in there that we can give for you as well. But the question I would throw out to you, and then other people may have questions, is how do state's attorneys exercise their discretion on determining whether to have a direct youthful offender, what is it called? Direct file, thank you.
Mhm.
Or makes a motion. Are the guidelines, I mean, how did state's attorneys figure that out?
Well, I would say very similar to how the court considers whether to accept a youthful offender during that youthful consideration hearing. The state's attorneys are considering public safety. They're looking at what the crime is. They're looking at the age of the person. They're looking at if there's any signs of whether that person's going to be amenable to treatment. That's one of the factors that the court looks at. And they're looking at, given the potential crime, given that juvenile's background, which they may or may not be aware of, but if they are aware of, given that background, what resources are going to be available to be part of that rehabilitative process. Youthful offender is still focus on rehabilitation. As you heard today, that, it does have that major stick of somebody going back to criminal court if they don't follow through, if they get revoked from youthful offender, but largely youthful offender is still focused on rehabilitation. So again, the court has to consider public safety, the amenability of the youth to being part of the process, and then what resources are actually available, not theoretically available, but in that county, what's available that the youth's going to be able to engage in, and again, within a short time frame, or relatively short time frame, depending again on the age of the youth, and then that cap of 22 for youthful offender.
So I guess a follow-up then is how different are the resources that are available in the different counties? Are there certain counties that are not pursuing youthful offender because we don't have the resources to address the individuals in that path?
I would not be able to quote a specific prosecutor who said that's the reason why I didn't do it. I know that when I was a prosecutor, it was most certainly a factor of what was available and what time frame one could get someone in. So if someone had if they were going into we were considering youthful offender and it was for a sex crime, very hard to find therapists who work with that group of individuals. It takes a very long time to get psychosexual evaluations before you can even take that next step of having that disposition plan. And so you could sort of be looking at what sort of time frame reasonably could happen depending on your resources. So I do think it's a factor. Again, I wouldn't be able to affirmatively say that someone said, well, sorry, I take that back. If I did not think that a youth could be served in youthful offender, and I did have a case like this where if it was moved to family court and we had a consideration hearing, and the major issue was that this person was, I believe, 20 at the time, maybe 20 and a half. But as we were moving through the consideration hearing, the months went by. He was then 21 by the time we got to the consideration hearing. And we knew from his evaluation, 1 year of any form of therapy or treatment was not going to address the issue. And so if I had known that information prior, that may have been a reason why I would not directly file.
So I guess just should be maybe a long introductory question, but I want to understand the differences geographically, because this is one of the big issues that we have is geographic justice on youthful offenders. So I know there's exercise of discretion of different states' attorneys. They have different viewpoints on public safety and the like. But then there's also the barriers that county for why youthful offender might not be pursued, including what I just asked about as far as resources, but it could also be how much of a backlog that you just alluded to that, how quickly are the cases being processed in the particular court in the particular county. The question you may not be able to answer right now, but I'm asking for the information, if you could gather that to give us an idea, how many youthful offender cases are being sought or that status is being sought, how many are being granted on a county by county basis, and then qualitatively understanding a little bit more about what the backlog is and what the barriers are. I'll leave aside discretion and who is different. I know that's kind of a wild card factor out there, because there's also the discretion of course, the court in determining whether they accept the youthful offender. So I'll leave those things aside. And I'm not asking you to answer that question right now. That's a request for information that I think would be handy. And is there anything additional from what I just asked for committee members that would be helpful for us to understand that aspect of this, which is the geographic equity component?
I have a related question, but it's not a data question.
Okay, so I asked mine and, but that wasn't really a request. It was a request, not a question. So, Representative Arsenal.
Can I make one comment?
Yeah,
to that
sure.
question before you go? I will happily reach out and see what we can gather. I believe the judiciary would be able to access the number of filings and or motions into YO and then how many are granted. They would have the most centralized information, I would assume, and break it down by county, but I will absolutely reach out to my department and see. I know a few of our counties take very detailed statistics. I just had one county send me her numbers and I would be able to give a snapshot for sure, but I will see what else I'm able to gather. But the judiciary also would have.
And I'm not asking for that by tomorrow either when you come back.
Fantastic. Absolutely not a problem. Or maybe next week or whenever part 2 is of
Right.
your meetings. I apologize.
So my question is very much related to this. And one of the things that I find fascinating about the job of a state's attorney is that they are elected officials and therefore to the extent that they, I suppose, deem themselves so beholden to constituents in a sense. So I'm wondering, and along the lines of geographic justice, when a state's attorney is weighing a decision like this, how much, if at all, does public sentiment play a role? I know that there are ethical guidelines, for the profession. So I'm not at all asserting that those would be violated, but I think that I would imagine there's something of a balance there, just given the interesting nature of an elected position with such consequential decision-making. So I'm wondering if anyone could comment.
So I had left discretion and you just backdoor discretion right into the conversation. So I'm impressed.
It's fascinating and important in geographic justice.
Yeah, no, it is.
It is an interesting question, and it's one that I think I would be remiss to speak for any state attorney about how much their decision-making would or would not be influenced by an election or just by public sentiment. I think depending on your state's attorney, how many the factors, public safety, amenability to treatment, resources, you might see some differences there, but that's coming from their perspective of how they, view the utility of youthful offender. And ultimately, we want to use youthful offender for what it does, which is protect certain young people from having a criminal conviction. I mean, that is the massive benefit, right, of youthful offender. But always also needing to weigh public safety, right? State's attorneys always are weighing that individual, their needs, and thinking about the juvenile's needs. They're thinking about the victim, if it's a victim-based crime, their needs, and the community need. Like those are always being weighed. So I think each state's attorney is going to maybe have a different balance on those scales.
Yeah, it makes sense. I know it's not a question that you can answer definitively. It's just one that I find very interesting and would love to hear a range of thoughts at some point, like just to understand, like I said, because it's such a consequential decision for the youth involved, wondering how much subjectivity there is.
And I think with respect to discretion, it's kind of interesting. It's also the courts and the defense counsel or the court can move for youthful offender.
Right.
So there's a little less of an issue with respect to discretion, perhaps. Maybe there's not as many direct files.
Right, and I guess it's the direct file I'm talking about, because if it's a motion, if it's moved by the court or the defense, then it's already been filed. It may have already been filed in criminal court, right?
Right. Good point. Yes. So Representative Goodenough.
Kind of get us back into discretion, unfortunately, another time. Is there consistency, and this is kind of regional justice too, is there consistency across state's attorneys' offices in Vermont on who's handling juvenile cases and who's making the decisions when it comes to direct files, if they're going to refer to youthful offender. Like I think in Wyndham, it's Deputy S.A. Cogden that does juvenile cases. I have no idea if he's the one that's making the decision to do a direct file or if he's got to go to State's Attorney Brown and he's the one who makes the decision. I don't know if that's how it's happening in Bennington. Is that like something that your office like knows about, or is there any kind of hope to have consistency across county on how that decision making is, that what the structure is?
I believe that would be county based on how the state's attorney runs their office as far as what goes through the state's attorney and needs to be approved or not. I believe that varies.
Did you do any direct file when you were? And I don't know for the 3
Yes.
years, were you essentially the Johns Cogden the third of?
Yes.
Yes. Okay. Yeah. So did you do any direct file to youth offender?
Yes.
How many?
Oh, boy, I would have to look back. I would not be able to pull an exact number out at all. But I most certainly did, because again, with domestic violence
Yeah.
and sexual assault cases, with sexual assault with children, I had a number of 15, 16, 17, 18-year-olds that I was trying to figure out the best way forward for everyone. So there were definitely some that were directly youthful offenders.
And in those circumstances, did you go through a victim's advocate to discuss that decision to do the direct file with the victim's family? Or was that a decision that happened before there was interaction with the victim's advocate?
It would depend on the case, but usually, especially with the cases I had, the victim advocate is involved from the very beginning, communicating. You've seen a million charts so far today of which ones, depending on the age, would automatically start over there. And we would need to explain why automatically the case starts in family court and the limits around that and what we would move or not move to YO. And conversely, like if we direct file to YO, we would be explaining that to the victim and then.
All right, thank you so much. I know that the hard stop is 1 minute past, but
Appreciate that. My son is a real, I get the TikTok.
So thank you very much again, and we'll have more tomorrow. And
I know we come off kind of short today and we're gonna,
she's coming back tomorrow.
right, but that's what I was gonna say. I know we're gonna kind of wedge her in or squeeze her in between some other witnesses tomorrow, but I would just hope that she gets all the time she needs.
We'll keep on finding time. Yeah, we're not gonna cut people off.
And just to foreshadow for tomorrow, to get you all excited, when we go through each of the scenarios, that's very much meant to be conversational. So as I'm going through, feel free to, ask those questions of like, well, why this, why that, why does that happen? Or so it'll be hopefully a fair amount of back and forth, not me just.
If you tell me are you flexible throughout the day? Because we can. Tell me.
I believe I am. If you gave me 2 minutes, I could double check that question. And then I'll just give my son your name. We live in South
I
Burlington.
think you have my number too, so, yeah.
Here's a- Wait 1 moment, thank you.
I will fit you in between 10:30 and noon. It's just if we need even more time, we could continue in the afternoon, so. We have some space there, although.
Yep. All morning, I can move one thing and then just in the afternoon, between 2 and 3, I'm doing introductions over in the State House with a few committees, but the whole morning we can I'll fit it in wherever you can fit.
All right.
And I appreciate it so much.
All right, thank you.
Thank you.
We're adjourned.